Deepan sir, should we start? Deepan sir? Should we start, sir?
Yes, we can start.
Welcome to the fifth day of short-term course on innovation, nobility, and intellectual property rights. A very good morning to one and all. The expert of today's session is a development professional with more than 10 years of experience, has expertise in policy design and implementation in the areas of innovation and startup ecosystem development in higher educational institutions in India. He has obtained his second master's degree in development policy from Korea Development Institute. He is currently serving at the capacity of Assistant Innovation Director at Innovation Cell of Ministry of HRD at IICT New Delhi. Shri Sahu is associating with AICT since 2017 and he is a core member of the implementation team for National Innovation and Startup Policy for Higher Educational Institutions. He plays a lead role in designing and implementation of number of other major national policy initiatives such as Atal Ranking of Institutions on Innovation Achievement, Institutions Innovation Council, and MBA in Innovation, Entrepreneurship and Venture Development. He manages a portfolio of various programs which are being implemented under AICT Startup Policy. Without taking much of your time, I am delighted to welcome and invite Mr. Sahu for his talk on innovation and IPR. Over to you, sir.
Thank you. Thank you, Dr. Shyam Kiran. And also thanks to NIT Jalandhar for organizing this beautiful faculty development program, and also continuously focusing on the theme of innovation, entrepreneurship, and intellectual property right. So this is my second opportunity to take the session because if many of you have already was part of the last time training program, so it's good that during this COVID pandemic period, many institutions are still focusing and trying to bring lots of innovation in teaching and learning and delivering the sessions and also spreading the knowledge among the our Indian aspirants like faculties and the students. So I hope in last 3 or 4 days you must have learned so many things related to intellectual property right, what type of IPR are there and their importance and where and how to register and how to get patent, how to get copyright. I hope you must have gone through these sessions earlier. And today my session is on innovation, entrepreneurship, and intellectual property rights. So I'm not going to tell about that how to register because there are so many other experts are going to or have already taken or going to take these sessions. But today I'm going to take the session that how innovation, entrepreneurship, and IPR are interrelated, correlated, and why we should focus IPR based innovation and IPR based startup rather than a simple innovative non-IPR based innovation startup. Though non-IPR based innovation, non-IPR based startups are very important, but when you are trying to focus more on IPR based innovation or startup, then actually it will bring the competitive advantage over others. Just for an example, consider that there are two firms are there, and both firms are doing the same business and they are offering the same service, but one firm or one company has patent or have a IPR on the products or service it deals with. That means it has the protection and has that right over selling or reproducing that goods and service, and in return of that a revenue generation out of it. But compared to the another form which is not IPR, maybe customers or the clients will not much interest, because there is high chance of getting it copied and other competitors will come into the market, and that way the business is always in a very risky and vulnerable situation. So that means what between the IPR and non-IPR based innovation and startup, that this brings the competitive advantage. So this is the one way a firm or any company ensures survival and success of its business. So today we are going to discuss all these things, and I will also make you aware about the IPR, history of the IPR, and how innovations are linked, and how human civilization since the beginning we have that capacity, and we have that ingenuity capacity to innovate, to come up with to have this intellectual property. So I'm going to discuss in detail. So let's get into the presentation, and I will not take I think it is, for me it is 2 hours, right, till 1 p.m. Sam?
Sir, yes, sir.
Okay, so
Yes,
the next 2 hours we are going to discuss lot of things, and also I'm going to ask very simple questions to get your consent, and also to ensure that you are in the same pace of our understanding. So let's get into the presentation, right? So let me share my slide. So is it visible? Can somebody will tell me, is the screen is visible or not?
Yes. Not yet, sir.
Is it? Just wait, let me ensure. Okay, I hope now.
No, sir. Could you rejoin through another ID? Yes, now it's fine.
Now it's visible?
Yes, sir.
The presentation. Okay. So
Yes, sir.
maybe system is a bit slow in responding to commands. Okay. So it will settle down, not an issue. Okay, so I hope you got the big screen, right?
Yes, it's perfectly fine.
Okay. Yes. Okay, so today's topic is on innovation, entrepreneurship, and intellectual property rights. And this is me. I'm not going to tell about me, because Dr. Sam Kiran has already mentioned in detail. And let's get into the subject directly. So let's begin with the human being, right? Because we all are human being, and I believe myself is being a human being, I am blessed beyond the imagination. This is my my thought, and I believe every human being is also thinking in the same line. Because why we are blessed? Because we are blessed not only with the ability to see, hear, and eat, enjoy in every possible sense, but also we have the capacity to analyze, to express ourselves, and most importantly the ingenuity, that knowledge that we have, and we have the ability to rectify the course of action or previous mistakes through our creativity and problem solving approach. So this is the quality of the human being God has given to us, and I believe this is the way. Actually, these are the points that we differentiate from the other creatures, and on contrast, that other creatures have not that not having these capacities, and they have no choice, and their own daily routine life is to take the birth, eat, survive, and perish, or die. But human beings are flourishing since the day one of the human civilization, and now I will show you that how human civilization has grown from million to last 7,000 years. So we actually, in process of development, we all human beings, or most of the human beings, we have forgot that it's a potential. We have all these potentials, and now the time has reached. So we have to realize, introspect ourselves, and to see that these potentials in us, and we have to bring it out, and you have to use these potentials for the development of our personal, for the professional career, also for the economic and social growth of our country and the nation, and as our whole world. So what the things actually we required? It required only two things. One is that the attitudinal change, and second is called the behavioral change. Attitudinal change or behavioral changes, actually it doesn't need money. Actually, changes is within us, and we have to only think. We have to change our course of action and also thought process. So what kind of change expecting? We're expecting that our people, or every human being, should think and should a attitude or mindset of job creation rather than the job seeking. And for this, they should use their ingenuity, capacity, and innovation and entrepreneurship qualities or the approaches to make this mind to happen, from job seeking to job creation. And the second changes we are expecting in all our human beings is develop the skill, acquire knowledge, and to tap out into our natural instinct and abilities to create better outcomes. Sometimes, or in many times, what we do, we just
Sahil sir, sorry to interrupt
excuse me.
you. Like there is a problem. Like your voice is breaking, sir. Could you rejoin from the
Voice?
second device of yours? Yes, it's not clear.
It's not clear.
Maybe some internet. Yes,
Okay.
sir. Maybe some internet issue.
Shall I join the web browser?
Hello, good morning, sir.
Yes.
Yes,
Sir,
Mr.
you should not join the other device. You should continue with this device only. But just don't make movements. When you move, your voice breaks. So you have to be still. And you can switch off your camera for better bandwidth of
Okay.
internet connectivity.
That is good. That is good.
Yes, that would be better, sir.
Okay.
Sahu sir, are you there? Yes, I request the participant to kindly wait. I request the participant to kindly have patience. Sir is joining from another device.
I hope my voice is going through right now. Is it okay? Can you hear me?
Yes, sir, it's fine. You can
Okay.
continue.
Sorry, actually, for the technical issues, because I found I was using the Mozilla, and now I'm using another browser. So I hope now there is no disturbance.
Yes, sir.
Okay, so let's continue from where I left. So we need three changes in our attitude level and the behavior level. The first one is the mindset, that starting converting from the job seeking to job creation. And second change is we're expecting that everybody should acquire the skill and knowledge, and we should follow what our natural instinct says, or the ability, rather than just following others and get into a wrong sector or the wrong domain, and later realizing that this is actually not fit for or not suitable for us. And the third thing we're expecting is that we should use our innovative and entrepreneurship ability to identify the opportunities and converting or identifying the opportunities and converting these opportunities into the solution, and bringing the changes at the social level, also environmental level and economic level. So a very famous quote by Professor Muhammad Yunus. He is the Nobel laureate in 2016. So according to him, human beings are independent and they are born entrepreneurs and not job seekers. So if everybody will try to become an entrepreneur, then there will be no question of unemployment in our society. So taking it forward, so just imagine that this is the timeline of human beings started 5 million years ago, and at present now.
Dipin
So
sir,
now it is.
sir, Dipin sir, sorry to interrupt you again. Sir, on the slides below there is like one icon and option of hide. Like
Okay.
stop sharing and another is hide. So kindly hide.
Okay, sure.
I did. Yes, sir. Thank you.
Yeah. So in the last, consider that in the last 7,000 years when human beings civilized, and since then the whole human civilization has gone through many stages with our revolutions. So it started with cultural revolution, and during that time only 5 million people were there, and slowly the agriculture, they started on agriculture and farming, so we call it agricultural and farming revolution. And after that, from 1543 to 1778, then another revolution came, we call it scientific revolution, and during that time total 500 million was the human population. And after that industrial revolution happened in 1780 to 1945, and during that time all this World War I and World War II happened, and during that time the total human population touched to 1 billion. After that a technological revolution happened, that is 1946 to 2013, and during that time the total human population reached 5 billion, and now we are going through a sustainability revolution, or also you can call it now fourth and fifth industrial revolutions, and during this time the total population is around 7 billion plus. And in all these revolution stages, the innovation and entrepreneurship and IPR has played the very important role, passing from the scientific revolution afterwards. And now you can see that in every stages that innovation came, and it brought one technical revolution and followed by another technological revolution. So there is a difference between technical revolution and the technological revolution. Technological revolution requires material changes. It uses tools, machines, energy resources, and production process. Whereas the technical revolution is restricted to change the management. So for an example, in technological revolution, somebody has developed a technology, or consider somebody has developed the LED bulb, and by using that LED bulb, there is so many use of that LED bulb in different processes, like reducing the energy energy waste minimization. So all these things is called the technical revolution, whereas the invent of LED bulb is a technological revolution. So always technological revolution happen, it leads to the technical revolution, again another round of through innovation and invention, another technological revolution happen, again it follow technical revolution. So this is the kind of a wave of innovation happen, and it's happening since last 300 or 350 years, from 1770 to till today. And in every stage there is a you can interpret in this way that technological evolution it creates a production possibility frontier, which leads to that is actually called the technical revolution, right? So technological revolution and technical revolution together leads to the economic growth, and during that time so many invention and discoveries happen. And just take the example of World War I. During the World War I, and because World War I fall during the period of the Industrial Revolution, and during that time so many technological innovations happened, and that actually shaped the IPR regime, not only in the Western countries, also across the globe. And just to take the example of or snapshot of few technologies that was invented during World War I, and still we are using few of technologies, and few technology has been developed and advanced, and now we have these advanced technologies. So this is the one of the technology, or one of the cargo carrier plane that is called army balloon or and hangar. So actually, during when World War One happened, during that time there was no ship or there is no aeroplane that carry the cargo or the ammunitions. So during that time, this this balloon airplane invented, and later this aeroplane has been converted into the cargo aeroplanes. And these are the fighter aeroplanes. Now you can see the Sukhoi or all the Jaguar, then MiG, all these Rafale. All these are the improvised version of the fight airplanes. Then submarines. So submarines also during the World War One, Germany was the lead in this designing of the submarines, and now there are so many submarines, advanced version submarines are exist in world, and these are the field gun, and now we can see that every country is using this improvised version of the field guns, and also one of the best example that India is, it's called the what is that gun we have used during the Kargil? Bofors.
Yeah, but T90 is also there, this kind of T90, sir.
Yes. So these are the improvised version of it actually, but these technologies were actually invented during the World War One, and now we have improvised it, and still we are using these technologies. So this is another British big gun was invented during that time. It is called machine guns, right? So this is not this is machine gun. It's continuously target the enemies. Then this is the first time US Army has invented and tested the bulletproof jackets during the World War One, and now you can see that in every army or maximum in most of the Western countries or even in India, we are using this bulletproof jackets. But it was actually invented during the World War One. Now comes to this German tank actually protected this, so it is sealed in such way that other tanks will also not destroy it. So this is another best example that how technologies during the World War One actually emerged and advanced in the due course of time. And these are actually jackets. Actually, these trench coats actually designed during that time to make British officers to work in the. It's a water resistance overcoat designed during that time for the army. For the British officers, but later it turns into a fashion icon, and now everybody is using it. So. And this is another example of blood banks. Actually, during the World War One, British Army has developed this portable blood bank, actually to provide bloods to the soldiers at the battlefield. And now you can see that how the blood banks the technology has emerged now. So. But it was begun with during the World War One, and similarly the sanitary pads also. Sanitary pads also actually it was discovered in 1914 and used during the World War One by Red Cross, and now the sanitary pad is being used in many occasions for many purposes. And similarly, this stainless steel actually it was. Developed by the British military again, and now we are using this stainless steel in many industrial purposes also. The jeeper actually it was developed during 1923. So this is also we are using now this technology in most of the things to zip two things. Like earlier they used to two cloths to strings to wind up, but now we are using the zip. Similarly, the wristwatch. Actually, wrist earlier nobody was using the wristwatch. They are using the pocket watch. But during the World War One, wristwatch came, and now you can see that how wristwatch is so popular, and everybody is using the wristwatch. No doubt, there is a digital versions came, but still wristwatch has its importance. Similarly, this drone. Actually, drone invented during 1918 only, during the World War One only. But now you can see that Israel, USA, they are leading in the drone technology. Even now, Indians also, our students now developing so many drones for the agriculture purpose, for the other industrial purpose, and also surveillance purpose. But actually, this drone technology came in World War One. So these are the technologies. So in every so the technology developed during this industrial revolution, still we are using, and now we are reached to into the fourth and fifth industrial revolution. So if you've gone through the time period between two revolution, you will see that the first revolution or the first two revolution took more than 500 to 1000 years. But later, the time period between the two revolution has been shortened, and now we have reached to a stage wherein every 5 year to 6 year or 10 years there will be one technological revolution will come, and now we are in fourth. But in other countries like USA and South Korea and Japan and other Western countries, they have already in the mid of fourth industrial revolution, and also they have entered into the fifth industrial revolution. So what is the, so if fourth is your robotic technology then and automation, then what is the indication of the fifth industrial revolution? So fifth industrial revolution is called big data, virtual reality, artificial intelligence, and cryptocurrency. So cryptocurrency is the one of the indication that fifth industrial revolution is already knocked the door, and many countries have already trying to embrace it. But in case of India, we are still at the beginning stage of the fourth industrial revolution. So we have to focus on that, how the technologies we have to get requisite skills and knowledge and competency, so that we will embrace this fourth. Also simultaneously we have to get into this fifth industrial revolution. So if you will see the into some data that how India is prepared for fourth industrial revolution, India is still lagging behind the other countries, and countries like Singapore, South Korea, Germany, Japan, US, UK, they are far ahead from India. And mostly when this graph was prepared, they considered the use of the robot and automation in manufacturing industries. So if you will see the manufacturing industries in India, still it is more a manual based, and the automation level is still yet to capitulate. Now comes to the automobile, and among all the manufacturing industries in India, automobile is the most advanced manufacturing industry. And even in that automobile sector also, India is still trying to cope with other automobile sectors in other countries. But we are trying to acquire the technology from other countries, and through collaboration and through kind of a technology transfer, our automobile Indian industries is trying to keep the pace with the global market. And there is a clear-cut gap exists between the when we are comparing with the fourth and fifth industrial revolution. The gap is called skill set. The gap is called the technology. And if we will not acquire that skill, and if we will not develop the technology, and if we will not use the innovation, and if we will not having that IPR based innovation, then because this big data analysis, this artificial intelligence, or the virtual reality, these are the fields are so overlapped that if you will not acquire that skill and knowledge and technology and intellectual property, then it is very easy to get copied and and others will I think some info is coming.
LP Singh sir,
So I think somebody has somebody has opened his mic. So please mute.
Yes, sir. Okay, sir has already muted it.
So there is a clear cut gap between a jump from a conventional to a automation, and the manual to a automation, and that is called the skill, technology, innovation, and intellectual property, where India should focus. Now comes to the I will not okay, let's tell about this stage. So actually this is the 5-stage growth theory given by the Rostow, and according to him, because he is an economist and he gave this 5-stage economic growth theory, and according to him, that every country has to go through these 5 stages of development, and it will start with a traditional society with the agriculture and subsistence agriculture system. Then it will convert into a industrialization phase, and there is a in between, there is a called transitional phase, and that industrialization is called takeoff phase. Actually in 1950 India and China both were in the takeoff stage, and but for the other countries like Great Britain or the Britain, Russia, United States, Germany, Canada, they have already reached to this takeoff stage in 18th century, and during that time they were all. That's why when India became independent, for us these countries we called as an advanced country, and India and China both were in the same stage in 1950, and during that time there are some structural changes happened in the economy, and after that China made a very good progress in its economy by using through the diversification, innovation, and more relying on the exporting the material to the other countries and expanding the market into the other countries, and India was quite lagging behind on these points. That's why China has gone one step ahead than India in the last 20 to 30 years, and that is the reason why actually India is also trying to focus, actually, because that is called stage 4. It is called the drive to maturity, and India still needs to focus on the diversification, innovation, IPR, and less reliance on the imports and more on investment and creating infrastructure and focusing on the export market. So that is actually where India is now has reached, and India is now focusing on this, but China has already reached to stage 5, that is called high mass consumption, and they are now focusing more on the consumer oriented service sector based innovations and the business. So the purpose of showing this graph is that how countries are moving from a traditional society to a high mass consumption, and actually in which stage innovation and invention and diversification is required, and how India is doing and how China is doing. So we're comparing. So the purpose of giving this diagram is this. I'm not going to cover this one. So now comes to the difference between invention and the innovation. I hope most of you are already aware about these two terms, and also have the clarity that what is the difference between invention and the innovation. See, invention is something that you invented, or it is something that is new, novel, as the utility. So this is the first time you have developed, and you have gone for protection, either as in form of the patent, copyright, or the trademark, or the geographical indicator, that is for another category. But these are the patent and copyright are the actually majorly considered as the invention. And innovation is that if that invention will be taken to the market in a different mode, either in a technology transfer mode, or either as a startup mode, or as a industrial use, then that called the innovation. So far invention is not used, not taken to the market, it is not called an innovation. this is the difference between invention and the innovation. And in a market driven economy, innovation happens when you figure out how to make money from the invention, whereas the necessity is the mother of invention, and profit motive and creativity are the parents of the innovation. So these are the basic difference and the comparison between invention and innovation. And if you will talk about the innovation, actually in 1934, Joseph Schumpeter, when he explained when he defined entrepreneurship, and he used the word innovation, and he said that innovation can be of 5 types, and one is called either that innovation you may call it if it is falling into either one of the criteria. So innovation is that if it is a new or improved goods and service. Innovation also can be a new method of production. Innovation can be a new market, and innovation can be a new source of supply, and innovation can be a re-engineering or organization of business management process. So these 5 types are called 5 types of innovation. But invention, if you will try to see, only in the a new or improved goods and service or a new methods of production will be the called till there will be some invention. But opening up a new market or exploitation of a new source of supply or re-engineering, this will be an innovation, but actually may not fit into the invention category, because generally it is not meeting the criteria of the invention. And the invention criteria, as I mentioned, a particular invention should meet 3 things, or a patent invention should meet 3 things. One is called N, means novelty, NUN, just keep for your short form NUN, none. Novelty, utility, and the newness. So these 3 things should meet the criteria, then only we will call it as a patent or invention. But innovation is beyond the invention, and innovation can be also non-IPR based. That is called the new market, new source of supply, or the re-engineering. So, as per Joseph Schumpeter, which is valid still today, that if somebody want to focus innovation, you should try to fulfill or meet at least more than 2 or 3 criteria of this innovation. Then only there will be chances of success or survival of that innovation in the market. Neither it will quickly get copied, or it will not it will not get that level of success in the market. So there will be innovation can be induced, and induced innovation comes through the creative thinking. So that as you mentioned, it can be product or the process innovation, and generally induced innovation comes in the reaction to the certain problem statement or certain situation that we have to overcome. For example, that when human beings observe that there is a labor shortage, and that which leads to the mechanized equipments, and also the drought conditions leads to the improvised or improved irrigation process, and the energy crisis leads to the higher efficiency cars. So these are the called technological innovations. Also there are some management related innovations also came, like farmers cooperative, small self-help group cooperative associations. So these are also kind of innovation came when they observed that individuals having subsistence agriculture or the less capacity to farming, they have no much bargain power, and they are always suffered in the market. That's why the innovation came in the form of farmers cooperative or self-help group form, and where like-minded people or like-minded farmers, they comes together, they form the association, they get the loan from the bank, and they start doing the business, and they have through this process they have increased the bargain power. So there are innovations which is non-IPR based. Also there is the innovation which is called IPR based, mechanized equipment, improved irrigation, high efficiency cars. So what is the incentive for these innovations? The first incentive is that patent. If you have if it is IPR based innovation, and if it is the intellectual property or the patent, then you will get the monopoly, or you will get the rights to reproduce and do the business, and for 20 years. Similarly, for the copyright protection is another incentive for IPR based innovations. That means that you can sell or you can commercialize that that art or that book or that material that you have developed and you have got the copyright. Similarly, the trade secret. So like Coca-Cola or the Pepsi, they are using these trade secrets, and they keep their formulas of creation of the concentration in secretly, and they are doing the business since last 60 years, 70 years. And similarly, the trademark is there. Trademark is to create the identity of your business or the products or the services you are offering. And similarly, there is also protection for plant breeders' right, and also if you have the innovation, you can participate in various business plan competitions or innovation competition or the startup competitions, and also you will get awards and the recognitions. And the most important thing is that if you have this IPR or innovation based solution, then there is a high chance to get into a startup mode, or you can start an enterprise, and also you will get lots of money or the business or the revenue out of this. So these are the incentives of innovation for both IPR based and also for the non-IPR based. So now comes to the what are the history or the let's understand about the intellectual property rights. And intellectual property rights actually it is not just recently phenomenon. Actually in 500 BC, actually this intellectual property originated. Okay, so during that time. Actually it is started from the Greek, and during that time it was only given for 1 year patent to come up with any kind of a if any citizen will develop any kind of innovation that is in the era of luxury. So it was started with luxury items and started from the Greek. And later they have introduced the patent, trademark, and copyright laws, and so it's not a recent phenomenon. We are this intellectual property started long years back, and slowly we have refined it, and we formulated lots of laws and the regulations. And the first law came in 1623. By that law is called the Statute of Monopolies, and it was a British law. And during that time, in the Western countries and the European countries, so during that time the process of industrialization is through guilds. So that means consider there are artisans for the artisans for the one type of craft, and there are artisans for the second type of craft. So during that time, artisans of particular craft, they form a guild, and and they have direct connection with the government, and government provide the raw materials and all the kind of requirements. And these guilds, they through this craft artisans association, they manufacture that craft, and they sell to the government, and government sell to the again back to the citizens. Actually that was the process during that time in 16th century. And during that time, European government, this British government, they said that guilds are the responsible for bringing all new innovations to the marketplace, and government gave the ownership and control over these inventions to use and to develop that craft. So this is the first time intellectual property has been came in the form of legislation. Then in 1710, first time the ownership rights given to inventor rather than the guilds. Earlier what happened, the inventor or the ownership right was given with the guild, not to the individuals, those have developed it. But in 1710, first time the ownership right was given to the individuals who has developed that creation or that innovation. And that's why they have decentralized and further refined the ownership right. And again in 1710, another called Statute of Anne, that is called, and that's provided that a 14 years of protection. So earlier it was only 1 year protection, later they have introduced the 14 years of protection to the inventor. And this is the way it has emerged. And later in 18s. So during that time when United States separated from the Great Britain, and the states under the US, they got independent, and every state has set up their own intellectual property protection law. But actually it was observed that during that time, when every state has their own intellectual property right, it's a protection law or the guidelines, actually to bring some the harmony, to bring some homogeneity in that law, then at the central level, at the federal level, there was a law in the era of intellectual property right. And actually this is from where actually whole world started looking into this intellectual property legislation procedure. And after that there are so many conventions happened. In 1883 the Paris Convention, again in 1886 the Berne Convention, and similarly in 1891 there is a Madrid Agreement happened. So similarly these are the called series of conventions and the agreements happened. And finally this World Intellectual Property Organization set off, and now they are the apex body of formulating and bringing the changes and the improvements in the intellectual property laws and the regulations at the global level. So these are the evolution and the history of how intellectual property has emerged. And if you will talk about the Indian patent system, the history of the Indian patent system, actually we have just copied from the British patent law in 1852, and then it got just modified in 1859, and it remained not much diluted, and only small amendments were made till 1999. So in 1999, first time patent, again it's amended version, but it's something improvised version came into the force. And in 2003 we made a big changes in the Indian Patent Act, and since 2005 it is effective. Currently the Indian Patent Act is effective. So we have adopted from British government, and we are doing some amendment, but the major changes happened only recently in the last 10 years. So till that time, majorly it was designed by the British government. So now comes to the IPR in its world landscape. So when I'm saying the IPR, mostly we are considering the patent, and though copyright, trade secret, trademarks, geographical indicators are the part of it, but patent is why you are considering the patent, because patent has the immediate use of the application. Also it is very easy to monitor because patent has the global, it is easy to get the data from the different sources and also validated data. And if you will see the graphs, and it consider the China, USA, Japan and Korea, that how the patent application and the granted happened since 1983 to 2018. And in 2018 the total application, the patent application has reached to 3.3 million, and total granted is around 1.42 million. That means it is around 40%. So 40% of applications convert into the grant. And from 1883 to up to 1980, so there is a kind of a flat. The world figure is quite flat, and after 1980, especially after the industrial revolution and the globalization happened in 1990. After that, there is a quite difference in the growth of patent application and patent grant for different countries. And the one of the deviation is called China. If you will see the China figure, it is one of the which actually made very steep growth or very steep upward growth after 2010. So till 2000, China is somewhat at the below the global average, and after 2010 something happened in Chinese economy, and now it is actually even suppressed the United States application and the grant. So this is actually one of the best trend or the phenomena we can observe or the between the China and other countries. And let's come down to the India's ranking. So in world, so China in patent, trademark and design, so China is top, and India is 12, 9 and 13. So this is called the IP filing activity. So this is the how many IPs, how many intellectual properties or other applications have been filed and granted. So based on this, India is though quite low, but we are improving. But one of the interesting figure is called China and US. So now earlier till 2010, US was in the top, and after 2010, China become the top. And other countries those are competing are Republic of Korea, that is called South Korea, Japan and Germany, and also France and the UK. So consider that another interesting country called Republic of Korea, which has the highest number of patent applications if you will compare with per unit of GDP. So India is far behind from the top 10 countries. So Republic of Korea or South Korea is the first, where the number of patent applications per unit of GDP is quite high. But interesting figure is that in 2008 it was greater than the 2018. But in case of China, it was just reverse. In 2000 compared to the 2008 to 2018, the number of patent applications per unit of GDP has been increased more than 3 to 4 times. So is it not interesting? It's that how that country is doing. No doubt we have so many things that we are telling, but actually also we have to understand that how that country is performing, how a particular country is performing. That will give us then insight. Also will give us something, information or the thought process that how other countries are doing and how other countries, because this is world data, and that's why it is easy to compare between the countries. And now comes another interesting figure, that is that this graph is prepared by considering the values, that how many patents applied and how many patents granted and how many patents rejected. So granted, rejected and granted, rejected and withdrawn. So before patent office reject, the candidate has, or the inventor or the applicant has withdrawn his application. That is called the withdrawn or the abandoned. So when you are taking these three things, then the most interesting countries are here is India, and another one is called Japan. See, in India, most of the things we are submitting, but actually it's getting we are withdrawing before it is getting rejected, right? So that means for the sake of application we are applying and we are withdrawing before the final examination. But in countries like Japan, withdrawn is less, but rejection, there is a rejection. But countries like Canada and Australia, where there is no rejection, so if somebody is applied, then he is very sure that he will get the invention, and either he has to withdraw, or if he will not withdraw, that means there is a high chance of that it will get granted. So see, these are the very important patents. You can see that, and that's also, this patent also is a reflection of what kind of patent rules you have in that particular country. Maybe the country like Australia and Canada, the patents are patent rule is quite flexible and not much stringent, but this figure what I'm showing is a world figure. This is from the YPO statistics, but YPO statistics says that it is some homogeneous rule. So maybe that particular country has some different rule, but this YPO, if somebody is applying patent for the international patent, then they have to go through the YPO process of patent application. So this pattern is quite for me it's very interesting. Also it fascinates me to understand the underlying process, why this pattern happened, by getting into that particular country's rules and procedures for patent. Now comes to the some comparison or between the China and India. So, or let's not compare. So let's understand that how China is actually doing good, and what are the 5 regions that China made a very steep growth in patent granted and patent application, or especially in the IPR activity after 2000. So just to understand that 2000 to 2015 and this China, so you will see that from 2007 or 9 afterwards, it made a very upward growth. And the purpose is that China started spending spending a very large chunk of its GDP in research and development. And China is the second largest spender on R&D after the US, which accounting for 21% of the world's total, nearly around 2 trillion in 2015. And China's spending on R&D grew with an average of 18% per year since 2010 to 2015. That means how China, how that, just understand that how investment in research and development help in making your IPR profile strong and also having a strong foot in world IPR landscape. So the first one is called a very heavy investment in R&D will lead that particular country in IPR regime. The second reason for China to reach to this level is that in 2000 to 2014, the annual number of Chinese graduates in science and engineering went from 3,59,000 to 1.65 million. So around how many? 4 times increase during a 4 years. So that means China has started focusing more on STEM education and also more on the science and engineering education, and they have increased the student base and they have focused on higher education, especially new generation of scientists in China are getting into the high-tech areas, and they are creating so many advanced technologies. And that actually leads to this type of growth in the IPR. Now comes to the third region. The third region of this upward growth of China is because converting this innovation, the invention into innovation. So far, you have these inventions, but not converting into the market. And now you can observe that in every startup in the world, you will find at least 10 to 20%, 30%, even up to 50% of money from China. China venture capitalist has spent lots of money in startups across the world. So this is actually another reason why China is in the leading this race. And the fourth reason is that venture capital investment in innovation. And China's, as I just mentioned in the previous slide, China's share of venture capitalist fund is growing, and while the United States share is declining. So that's the reason why US is losing its position since last 5 to 6 years. So this is the world overview on IPR invention and how China is doing and what are the reason behind this tremendous growth of China's IPR regime. Now comes to the India's perspective. If you will consider the India's perspective, India spent only 0.7% of its GDP. Okay, so China spends 2.1% of GDP in R&D. Other countries, Japan, US, China also spend. Japan and US also spend lots of money in R&D, and in last or in the figure is by 2017. So more than 6 lakh applications were filed in the US, and more than twice that number in China. So that means in India is only 46,000. So just compare that 6 lakhs figure and 46,000 figure. How that actually where we are. This is the growth of different IPR like patent, trademark, and industrial designing and GDP in India. And so far, this is the figure of 2019 from YPO again, and there are around 30,000 patents and 333,000 or trademarks and 15,000 or industrial designs. So these are the achievements or our IPR achievements for our country. And again, I have taken the figures from DPIIT, Department of Industrial Promotion, and under the Ministry of Commerce. And there is a comparison between 2013 to 14, 14 to 15, and of last 5 years. No doubt the number is increasing, and every year it's a good trend, it's a good sign, but the total number is still far behind than world average of the top 10 countries. If India want to become the top 10 or under the top 15, then definitely we have to focus on strengthening our IPR regime. So we have to strengthening our IPR activities. We have to come up with lots of inventions, lots of patents, and also other forms of the IPRs. But only getting patent is not going to give that competitive advantage. We have to convert that invention to innovation by spending lots of money, by spending lots of capital and venture money or the investment in startups and in technology transfer. And this is the way India can plan. And there are so many things to learn from the other countries, and the cross learning should be there. And then we split this total patent applications from the resident and non-resident and abroad. So the most of the applications came for India is non-residents, like the NRIs or the Indians residing in other countries. They produce and they file the patent. That is because actually this is one of the major reason behind this is that India has lack of infrastructures. India has the lack of that system to create more inventions. And I believe that India being the one of the largest education system in the world, and we have a very good student base of more than 2.5 crores at any time, and also we have more than 50,000 higher educational institutions. If India will start focusing on capitulate that this figure, and you have to use this the creativity potential of our Indian youths, especially those are in the academics, then definitely we will able to create some difference in this domain. And also India in next 10 years to 15 years, there will be a very big opportunity and ground for India to play in the international domain also. And but for that, India should start acting on it, and we should prefer to work on it. And when I'm saying India means it's not the only the government; it is the every citizen of our country is called. We all together we call it India. So now comes to the patent applications filed by Indian scientific organizations or academic institutions. So during the period of 2019, the data is here with from 2009 to 19. It's for 10 years data. So institutes or academics has contributed up to 25,000 total in the last 10 years. Total 25,200 patents came from the academic institutions or scientific organizations. So number is not much high, but again we should not feel proud, but we should we are doing, but it has to be increased to at least for me, if you will ask me what should be the ideal number, it should every year at least 30,000-40,000 or 20,000 of applications should come from every year. I'm talking here every year is only 3,000, at least 20 to 30,000 of number of applications in the area of in patents or copyright should come from the academic institutions. So this is the way we can set the target. Now further breaking down the organizations, IITs, NITs and Council of Scientific and Industrial Research, CSIR, are actually, and DRDO also up to some extent, they are actually leading in the patent filing or application filing. How many are getting granted? That's a different question, but at least these institutes are good at application filing. Also there are other institutes, also there are some lead academic institutions and universities also started filing these numbers. And Samsung R&D Institute of India, Bangalore, these are the corporate which Samsung is filing 1032, and our IITs all together is filing only 3,751. So that means it will be very difficult to compare, but actually these our students are actually going into doing this R&D in Samsung, and they are filing the technologies, but our institute has so many facilities and infrastructure, but we are not filing patents as per the expectation of our country. So there are so many things, but definitely we should think about it, that every institute, every student, every faculty start using their capacity, and they have to use the resources of our institute, and we should target at least 20,000, 30,000 patent filings every year, especially only from the academic institutions. And another list of institutes, those are filing these patents, and there are good names, and I can remember Chandigarh group of college, maybe from your region, from the Punjab, Chitkara University, and of course the NIT Jalandhar is there in the under the NIT category. And also there are other universities from Uttarakhand, I think Solini University is from Uttarakhand, or some other universities. So there are so many universities are there, they are spread across the country, and we are getting, but still number is not high, but okay, it's improving. Now comes to the how Ministry of HRD initiatives, we are focusing on improving India's position, not only in the innovation, also in the IPR. So in the last 5 years, India made good progress in Global Innovation Index. Now we are 52nd position, and we started in 86th position 5 years back. And also we made good progress in global entrepreneurship index. Also we are progressing in World Bank's doing World Bank's ranking on business, doing the business ranking. And also we are making progress in IPR under the YPO ranking, that as I shown in previous slide earlier, that we are in top 15 under the patent and copyright and trademark. But the effort we have to put lots of other efforts. And DBT, Department of Biotechnology, NRDC, National Research and Development Corporation, DST, and other ministries at the central level. Also at the state level, there are many agencies. They are focusing on improving India's position in innovation map, in entrepreneurship map, also in IPR map, in the world map. Similarly, Ministry of HRD, because as I said that India's education is one of the largest education system in the world, and that's why Ministry of HRD, now it is called Ministry of Education. We have started this innovation cell 2 years back, and the purpose of having these policy initiatives in the area of promoting innovation and entrepreneurship and IPR to make our country or our education system more innovative, our education system more entrepreneurial. Also our students should think, act innovatively, entrepreneurially, and also should take entrepreneurship and startup as a career option. And finally, the objective is changing the mindset from job seeking to job creation. So with this mission and vision we have started, and now we have so many major programs we are implementing. You might be aware about the Smart India Hackathon. We are doing since 2017, and 17, 18, 19, 20, so 4 versions already over. So the objective of Smart India Hackathon is that bringing the government and the industrial problems, the real problems, and giving these problems to students, our students, and triggering the creative mindset to propose the solution, and with support from the government and industry, further taking that solution into a innovation form and further leads to a startup form. So the objective of Smart India Hackathon is to trigger the creative tendency of problem solving skill set. So this is called the Smart India Hackathon. And in the last 4 years, we started with software edition and started with the only government problems from the ministries, the central government ministries. But later we have included the ministries from the state governments, and also we have included the industrial problems. And now it is well adopted and accepted by our students and academic institutions, and they are participating in these competitions. Similarly, the Institutions Innovation Council, and I hope most of you are part of this Institutions Innovation Council set up in your institutes, and you are involving in that in many activities in promoting innovation and entrepreneurship. Under this Institutions Innovation Council, we have created a subcategory called IPR activities, and through that institutes are given certain activities to conduct these IPR promotion and support activities. Also, institutes are allowed to do so many self-driven activities in this area. And the purpose of establishing this Institutions Innovation Council is to break the isolation existing in the institutes where the departments are working in isolation, and also the resources in one department or the one center is not being utilized, and also there are no continuous efforts or activities are happening in the campus towards promoting and supporting innovation, IPR, and entrepreneurship in the campus. So institutions innovation council ensures to bring the synchronization and attain the attain this called coherency and synergy among the departments and the students, faculties, and putting a focused effort towards conducting activities round the year, and also as per the requirement of the students and the faculties, and to promote and support innovation, entrepreneurship, and intellectual property right activities in the campus. So this is called the Institutions Innovation Council. It was started in 2018, but now in the 2 years we have reached to more than 1600 institutions. Innovation Council has been established in higher education institutions, and in the last 1 year our outreach through our institution innovation councils, it reached to more than 52 lakhs students and faculties, and just recently we have completed innovation ambassador training program, and under that innovation ambassador training program, intellectual property right training on IPR is one of the subcategory, and we have trained more than, I think, 2000 faculties in this area, and all total we have trained 8000 innovation ambassadors, and around 2000 are under the theme of innovation, IPR, and intellectual property right. Similarly, now Atal ranking of institution on innovation achievement. Just recently we have concluded the 2020 edition, the second edition of ARIA 2020, and Honorable Vice President of India has announced the ranking, and there are so many NITs, IITs, also government institutions, government universities, national importance, Institute of National Importance, and centrally funded technical institutions, deemed universities, private colleges, standalone colleges, all were participated in huge number, and also more than 310 institutions have listed and also received ranks and the bands that we have formulated for different subcategories. So again, we are going to start the registration process for next year 2021 very soon. Most probably in next 10 to 15 days we are going to announce the registration process, and my request is to all the institutions or the faculties, those are participating here, to communicate and to participate in this auto ranking process. Also establish institution innovation council in your campus, and also encourage your students to participate in Smart India Hackathon. And another training program we have just concluded is called implementation or adoption of national innovation and startup policy for student and faculty in higher educational institutions. And this policy actually gives an enabling environment or policy environment for the institutions to give some kind of relaxation, and we called some kind of incentive for faculties and students to work on their innovation and also start an enterprise during the academic itself. And in addition to this, also we are running other international hackathons with other countries, like we are conducting Singapore India Hackathon, also hackathon with ASEAN countries, hackathon with Western countries like Portugal, Portugal hackathon, India-Portugal hackathon. Also, we are exploring the hackathon with other countries. It is under process. So these are the some activities, some programs we are we have, and also we are planning to come up with certain policy and schemes for to support, to promote intellectual property right. And we are now concurrently in formulation phase, and when it will be finalized, then it will be announced to the all the higher educational institutions. So as I said, this NISP 2019 is quite relevant to you all, because this policy intends to guide our higher educational institutes to promote students and faculty-driven innovation startups, and also it considered to be an instrumental in leveraging the potential of students' problem-solving and entrepreneurial mindset, and promoting a strong intra and inter-institutional partnership. And these are the thrust areas of NISP 2019. It has 6 thrust areas. So I'm not going to cover all these thrust areas, but I'm going to tell the thrust areas that is called the fourth one. The fourth one, the D one, this is called IP ownership right for technologies developed at higher educational institutions. So this thrust area of NISP says that in an higher educational institution setup, if any faculty or student has developed any technology, and the technology has that patentability component, and if the faculty and student has not utilized any resource of institute, or have not, I'm saying not any resource means that is any resource in substantial way, using the internet, using the hostel room, using the these things is okay, but library is okay. So but they have not utilized any hard infrastructure or the institute, and also not any money or kind of fund of institute to develop the technology, then institute cannot claim ownership on that technology, because that faculty and student has not used the institutional resource. But in case the faculty and student has utilized the institution fund, or the fund channelized through the institute, and the resources available at institute, the infrastructure, especially the machinery and the equipments and all these lab for developing the technology, then institute should be considered as one of the co-owner of that technology. So that means ownership right, earlier it was not clear. That's why in many cases we have observed that faculties generally develop the technology by using the institution fund and institution resources, but total ownership they have taken on their name. And also similarly, also many institutions they have taken the ownership even if the faculty has not utilized the resources. So in both cases we have observed both cases. Also we found that students, those are actually part of the invention creation, and but they have given the certificate, but they have not obtained, they have not given the ownership. So there are so many discrepancies in the irregularities we have observed. That's why this NISP encircles this IP ownership. Also this IP ownership says that if that intellectual property or the patent held by faculty, student and the institution, and if they want to transfer the technology in the form of license to any startup or any industry, then there will be a revenue sharing mechanism between the student, faculty and the institution. Also if that faculty or student as the part of that invention, if they want to start a startup to take that technology forward, then also institute has to give the permission. Either they can have the stake in that startup as in equity, or they can give they have the kind of a licensing of the technology to the startup, and in return of that institute can get the revenue from the total sales or the turnover. So these are the kind of defining the gray areas, especially in the IPR exists in the higher educational institutes. And please go through the NISP policy document and you will get detail of it. So with this, I will end my today's session. with the quote and with the statement from our Prime Minister sir, that I remember it was in 2015. He gave this quote. He gave this statement, and he said that I see startups, technology, and innovation as exciting and effective instruments for India's transformation. So we are now have a good vision and a governance system in place, and also whole country, whole state, and all higher educational institutions and every citizen. Now we are aspiring to make a $5 trillion economy of country by 2025, and that is our target. And to make our country to a $5 trillion economy, so we have to focus on startup, innovation, and technology, and ultimately the invention is the intermediary output of the technology and innovation and startups to happen. And because, as I said, that this is going to bring the competitive advantage in for our industry and for our country as a whole. And with this, I will close my session here, and next 10 to 15 minutes or 20 minutes we have the question and answer session, and after that we will wind up the session. So Dr.
Thank you, sir.
Now,
Yes, sir. Thank you very much for this wonderful, magnificent, superb, and of course, innovative lecture. Now, I request the participants to please kindly ask questions one by one. You can ask questions directly to sir.
Hello, sir. Good afternoon.
yes.
I am Vishnu from Kerala. Actually, I am a patent analyst. As I am a patent analyst, I am analyzing hundreds of patents in chemistry and drug substance monthly. So when I look at the Chinese patents and the Indian patents, I am analyzing actually US, W, Chinese, Korean, and Indian patents. When we look at the Chinese patents, it's like even the small compounds. If you look at the chemistry patents, some compounds they will isolate from some herbals or something like that. If they got a structure or like a compound, they will check some little things and they will publish a patent. In our academic, so many students are doing like this, but they are not doing any patents or such kind of things. They are not even publishing paper for that. So why in Chinese they are allowing such kind of patents and in
See, even I just tell me you are agree or not agree to my statement.
Okay.
What you have said just now, that 5 lines or 10 lines, that is completely your interpretation, and that interpretation came from your heart, mind, and or not. So that means what you have said, that is your word, that is your interpretation. That means it's your own creation. So actually, what our mentality is that we are just trying to give it up, and ignorance is still a dominant in our thought process. But in case of Chinese, they have learned how to, because they learned how to make how to lead the race, and then that's why they have, earlier they were also the same ignorance kind of thought process, but actually they learned from the Western countries, and especially from the US and other countries, and they said that okay, if any country want to lead the world market, then you have to protect each and every, so that others will not able to reproduce it. Okay, and that is actually with that aim. And also there the governance system or the government system is there, and the government system, because it comes under only there is no much kind of a much decentralized, then it is very easy to implement that policy if that government wants. But in case of India, if you will start implementing this kind of policy, first thing is that there will be lots of restriction, a lot of agitation, and kind of lot of reluctance or the complaints you will get from the common people, and by citing that okay, this is not good for our country, or this is a violation of the people's thought, something like that, you will get so many complaints. So that's why in case of India, it is very difficult to implement very minute detail things, because they will tell you that you are hindering our freedom of something like that, they will tell. But in case of China, this is not the issue. That's why they are able to implement in a very forceful way, or in a very autocratic way. That is we cannot do.
And sir, if you send for some patent analyst for even for searching, they are saying like 25,000 for that, and for patenting 75,000. Then it will be like hard to patent, no? Then people won't go for that. So it's like from government there should be some help for this academic institution or some other person if they want to patent. So this much amount they won't spend, no, for patent and all.
This if they want.
Hello, sir.
Vipin sir, are you there? Yes, please wait.
Yeah, okay.
Hello.
Hello, sir.
Hello.
You're audible now. Yeah.
Yes. Yeah, some network issue came. Yeah, next question, please.
So good afternoon, sir. This is Pradeep from Hyderabad. So can you throw some light on Atmanirbhar Bharat Abhiyan and IPR with related to the AICT and Ministry of Education?
Yes. See, Atmanirbhar, if you are trying to find the dictionary definition, Atmanirbhar will be different than the what Atmanirbhar in literally we understand. One example that everybody will try to correlate: when a student after his intermediate join a bachelor program and start staying in the hostel, then from the day one he has been exposed to a different atmosphere and surrounded by the people student from the different parts of the country. Also, they have different food and culture. Also, the ragging or something like there is a fear of ragging from the senior. Also, to cope with the education system or to cope with the coursework. So within that also, with given a limited budget given by their parents, they survive, they thrive, they try to have a collaboration, they try to have a independency to do excellency in the academic. Also, they try to manage the budget with the given challenges and the constraints. Also, they by end of the third year and fourth year, they emerge as one of the best student. Also, they fit for the industry, or they start their own startup. So if you will see the things, how a student will start beginning from a scratch, and within next 3 to 4 years they emerge as one of the successful person or a very potential graduates having all skill set related to the management, entrepreneurship and technology. The same way Atmanirbhar is that. The Atmanirbhar says that you see, we could not stop our current activities, that okay, don't depend. It's not the Atmanirbhar. We have to depend, but we have to reduce the over dependency on others, and gradually we have to acquire the skill set and the capability to produce within our territory. So first thing is that we have to see that where we can start producing within our system, and where we have to depend, and where we need collaboration and or co-creation. So it is the mixed approach of self-sufficiency and also the collaboration, co-creation, also creating the capability. And it will take time. It will take time of 10 years, 5 to 10 years.
Sir, I have a question. Now, when it comes to perhaps United States or such other countries, in terms of trade secrets, while they could, implement successfully and run their companies like, the Coca-Cola, Pepsi and all, somehow I'm feeling that the aspect of trade secret, we don't deal much in intellectual property rights, especially in India.
Yes. In trade secret, India is lagging far behind.
So, is there something, we can think of, sir?
So actually, trade secret, actually, no need to file it. Okay,
Yes.
trade secret is something you want to keep it secret. So it depends upon that you have that secret or not. If you have not that secret, then there is no trade secret. That is the only simple way we can interpret. So that means it depends upon that particular individual who has developed that secret. If we have not developed that secret, and if you are not able to maintain that secret, then it is very difficult to have that trade secret.
Okay, thank you.
Any other question?
Hello, sir. Hello.
Yes, Mr. Vishnu, you can continue.
Yeah. So
can ask.
if I have an idea that can improve, that can make an improvement in any of the company, if I'm a chemist, so I have some new ideas, so that they can one company can improve. So I approached them, and they came with some funding, and also I have done some research, and also after that they can improve their product. So how I can concise that product within that company and me, so that is their funding, so that there will be some secrecy, so that me and that company only will be with we should only that have that secret. So how I could or like we could concise that secret in between us with this laws and all. Hello.
I think there is some technical problem, so just wait for Mr. Sahu to rejoin us.
Okay.
Vishnu, please repeat the.
Now you can ask.
Yeah. Hello.
Yeah, please repeat the question.
Okay, so if I have an innovation or like something that can improve a product from a company, so I approached that company, and they gave me some funding, and all. After some research, we both together we have improved that product, and company launched that product. So after that, there should be some concise legal agreement between me and that company, so that I should not reveal that idea to any other company, or they should, without my permission, they should not give to other, because that is my idea and they are funding that. So between me and that company, there should be some legal things, So how
Yes.
I can improve on that, means do on that kind of things.
Actually, it depends on, at the beginning itself, there will be a dialogue and the discussion between the who is going to fund and who is going to give the idea. So it is between you and the funder, the funding agency, and it depends upon your capability or their so it's a during that time a negotiation will happen, and based on that you have to do the agreement there itself, and that agreement also clearly state that on the final product who has what level of what percentage of the stake, and how it is going to be delivered, and how it is going to be transferred, and what is the license way. Everything you have to state at the beginning itself, and it should not be discussed at the end, because the way you are giving your intellectuality, they are also giving their time, fund, and also the risk. So both parties are bearing the risk. So you have not that capacity of generating the fund or the having that intellectual resources, right? So in that, they have that funding resources. In that way, you can have the negotiation.
Okay, yeah, thank you, sir.
Any other question? Any other question? I think it's fine, sir. Thank you very much,
Yes.
Dipen, sir. And we are also thankful to the participants. Am I audible to all?
Yes, ma'am, you're audible.
Am I audible?
Yes, ma'am, it is audible.
Okay.
Your voice is
So
audible.
once again, like we express a sincere gratitude to Dipen sir for this informative and wonderful talk. Looking forward to meeting you again, sir. And I'm sure that our participants, they will definitely think something innovative so that it can or they can work something good for our country as well as for themselves also. So thank you once again, one and all. Now we'll meet again at 3 p.m. for the next lecture by Dr. SSN. Thank you.
Thank you. Thank you all. Thank you.
কালকে কোথায় ছিল আজকে একটা সবাই কোথায় ছিল
मैंने किया ओपन अभी जस्ट.
Welcome, sir.
Yes, am I audible to all?
Yes, sir. Yes, sir. Good afternoon, all. It's a great pleasure for me to introduce the speaker of the session, Dr. Suman Sher Singh, who is going to talk about various funding platforms and facilities under Institution Innovation Council. Presently, Dr. Singh is working as Joint Controller of Design and Patent Office, Delhi. Dr. Singh did MSc in 1985 from Jivaji University, Gwalior, and PhD Organic Chemistry in 1989 from Meerut University, Meerut. Dr. Singh has joined Patent Office in 99 as Examiner of Patent and Design and Deputy Controller of Patent and Design. Before this, Dr. Singh was Scientific Officer in National Test House, Kolkata, Ghaziabad, Mumbai. Dr. Singh has total exposure of 34 years. And Dr. Singh has happened to visit overseas one time in WIPO, Switzerland, Geneva in 2005, and 2 times in Japan Patent Office, Tokyo, Japan. Presently, Dr. Singh is working in Patent Office, Delhi as the head of General Patent Matter section and supervising patent matters of registration of patent assignments, alteration in patent registration, restoration of lapsed patent, opposition to grant patents, and litigation in higher courts. Now, I would like to request to Dr. S.S. Singh, sir, please join for the session. Welcome, sir.
डॉक्टर सांबे जी मेरा प्रेजेंटेशन दिख रहा है क्या?
No, sir. Just click on present now.
प्रेजेंट नाउ तो ये डिसेबल्ड आ रहा है इसमें, इस वक्त देखा मैंने.
Sir, I think you can disconnect and again, yes.
मैं डिस्कनेक्ट.
Yes. So now that button is enabled, present now.
हाँ अब तो मैंने सब कर दिया इसको. शेयर माय स्क्रीन.
Okay, sir.
आया दिखा आपको?
No, sir. Maybe it will take some time.
नहीं वो वही प्रॉब्लम है. मैं एक बार कैमरा निकाल कर दोबारा लगाता हूँ उसका.
The camera is working, sir.
Can't you share your screen? You must grant permission in order to screen share. Present now. Entire screen.
Yes, sir.
Okay.
It's presenting now. Yes, sir.
So
you can open it presentation mode, full mode में open कर लीजिए. Otherwise, it is also okay.
Okay, visible?
Yes, sir. Fine, sir.
So, dear participants, as much as this topic is concerned, that is, financial assistance to file a patent. I should be true with you that because I am sitting on this side of the table, so I am not actually practically informed of the same. But as much as I am being informed by others, I can share my knowledge with you that there are certain departments like the Department of Science and Technology they have a TIFAC, there is a department, Technological Information Forecasting Center. And they have provision, to support the genuine inventors to assist in filing, even in drafting also they help the inventors. And monetary wise also they are giving some money. So why not? Let me share this. Because you are able to see my screen, so let me go like, and as we are sitting working together. So if you click here, I think you are able to see my screen for this surfing the internet.
Yes, sir. Yes, sir.
Okay, so here if you see that there are schemes, recruitment programs, technical TIFAC technology, and recruitment call. Simply I write patent here. Patent. No, I think better to go to the DBT, about TV, media room, downloads, useful links, recruitment. Let me go some other side, DST. Call for proposal. So the so one of the program attached to them is this IPR Kiran. In this program, even they give training to working the women, specific only for women. This program is meant for, and they give good amount of scholarship also. I think 30,000 something they are paying, and for 1 year they give training to those women in different patent practicing firms. And sometimes they send people, candidates to our office also. But this is somewhat like, to create the entrepreneurship among the women. But if you explore more in their website, they are paying some money also. And there are other subsidy programs of this for MSMEs. But they are for SMEs, not for some individuals. So for individuals, I think only TIFAC and Department of Electronics is also giving some assistance. So I have not proper slides also for this deliberation. You can please raise your question, any specific question, then I will try to answer your questions, and by that way we will be able to interact better. Please raise your questions. Hello.
Yes, sir.
आप क्वेश्चन रेज कीजिए. आप जो पार्टिसिपेंट्स हैं, देयर आर 85 पार्टिसिपेंट्स.
Participants, if you have any question, then you can ask directly.
सबको अलाउ कर दीजिए, कोई भी क्वेश्चन पूछ सकता है.
Sir, I have a question related to copyright. If you can answer.
Please, copyright. I will not be fair to answer you exactly.
Actually, sir
Like-
is looking
just
patent.
like-
So please ask the questions related to patent, and it will be fruitful for all. Please.
Dr. Singh, this is Avinash. I have a question.
Sir, I
Dr. Singh, can you elaborate for individual private inventors? Can you take us through the procedure or through any facility that Government of India provides, where they provide financial help, they provide technical help in drafting, in application submission? So if you have anything, any material, can you help us go through this?
पंकज मैं इस NIT जलंधर वाले प्रोग्राम में हूँ 2 मिनट के लिए हैं हाँ बस 10 मिनट में आता हूँ वापस से हाँ मिस्टर अविनाश सिन्हा जी क्या पूछ रहे थे आप प्लीज
Yeah, Mr. Singh, what I was asking is, can you elaborate on facilities in terms of both financial facility and technical and assistance facility that Government of India or any other organization provides for private inventors, individual inventors who are not associated with any organization, either private or government? They are individual inventors. So how do they go about?
So that was what I was putting you in the right picture, that because I'm sitting on this side of the table, I mean, I have not explored all these things, but this much I know that for SMEs there is a scheme for individuals. I mean, TIFAC is providing some help, and 60 there is also one organization 60. They are also providing some assistance to individuals. But what sort and what way they provide the assistance, that please you have to explore from their available resource, and I don't have that information on my tips.
Okay, Dr. Singh, thank you so much.
Yeah, but I just share with you that as and when you feel that you have any good invention with you, you please communicate with me through email or my mobile phone. I then and there I promise you that I will explore all possible help you. To motivate you to go ahead in any other efforts. That I promise.
Thank you, Mr. Singh. I will definitely do that. Thank you.
Okay, welcome.
Hello, sir. Am I audible?
good afternoon,
Yeah,
sir.
you are audible.
Yeah, yes, sir. I have one doubt. Can we put clients in the provisional application?
Please.
Please repeat. Can you?
Can I put clients in
Sir, good
provisional
afternoon,
application?
sir.
Clients.
Yeah, clients.
So one by one, please.
Hello.
No, you see.
Rashmi, yes, please continue.
I told you first day that there is no requirement to have claim in provisional specification. But that depends upon you, because we cannot stop you to write anything in your specification. But that will not bring you benefit, because if you write some claim, and in coming course of your further development of your invention, you have come with different wordings or different scope of the claims, then it will be difficult for you that will fall under the amendments of the claim procedure. So better, when you are not doing any benefit and any actual any protection of those claims, what is the need of mentioning the same? You keep with you, and within 12 months time, you can, when you are ready with your invention completely, you can file your claims with the actual scope of your invention.
Because I'm asking after provisional application filing, I can contact some
hello, I can contact someone who can buy or who will try to implement my invention. They can see the claims and they can get to know how strong the patent is.
In that case, that means you दूसरा प्रोग्राम चलता है जलंधर में हाँ नहीं मैं आता हूँ पढ़ना so and I was telling that as you are explaining, it is understood that you are compared with your invention. That's it. That is why you want to share your invention with the market. You square your
yes, sir.
Your commercialization. So in that case,
yes.
In that case, you go for the complete specification and file the request for early publication in Form 9. So your application will be immediately published within 30 days of your request for in Form 9. And only then public will come to know about your invention, and then you can explore the possibility of contacting the others in the interest of your invention.
But problem is, sir, they can suggest some changes in the patent also. That's why I would like to file provision first.
They are understood that patents are claimed for those subject matters which you cannot keep to your chest. If you can keep to your chest something, then better you go for the maintaining secret of your invention. Don't disclose anything. But if you are not able to work with your invention without disclosing the facts of the invention, then don't worry about mentioning the same patent specification, because you have been given it previous day. And in future, if your invention is worthy of patent, you will get patent. So date of patent will be from that day, and from that day you can sue any person for infringement.
No sir, after filing the provisional, when I contact somebody who can buy the patent, they can suggest some changes. So then I need to change it.
If you are filing provisional, that means you are not complete with your invention. And if you are not complete with your invention, who is going to buy invention? Investor will take interest in buying any technology with you, for which you are not complete in yourself. Because everybody wants some written proof, but you need not to worry that disclosing your invention and patent specification will allow others to work the invention. They cannot work the same invention. And if somebody does that, and that means he is fool, because tomorrow patent is going to be given to you only, not to him. And as soon as you will get patent in your hands, you will ask him to stop his work, and that you are infringing my patent, and he has to close down his plant, complete plant. It will be in the law. So no interested person is going to copy the invention which is already disclosed in previous day. Suppose you have disclosed something which is not patent worthy, then you cannot nobody is supposed to be worried about your patent application. Because everybody has a right to oppose your application also in pre-grant opposition, and even after grant of the opposition, and even after that somebody can file a suit of before the High Court to revoke your patent.
Okay, sir. Okay. Thank you, sir.
Okay. Next question.
Good afternoon, sir. Hello.
Yes, madam. Continue.
Am I audible,
please.
sir?
Yes.
Lakshmi Narayan.
Rashmi, sir. It's okay. Sir, I have a question. Whether the indigenous knowledge is patentable
I am reading through my Mr. Dr. Sambit, my screen visible for Ministry of Electronics and Information Technology?
Yes, sir. Sir, we have a question from Rashmi.
Yeah, बोलिए रश्मि जी.
Sir, we know that indigenous knowledge is a community knowledge which cannot be patentable. but somehow we can see that the indigenous knowledge is misappropriated by
आप लोग चैट बॉक्स में लिख भी सकते हैं, मैंने चैट बॉक्स ओपन कर लिया है, यहाँ पे मैं पढ़ के आपको जवाब दे सकता हूँ.
Yes, please, ma'am, write your question in chat box. It will be easy.
Okay, sir. Okay.
देखिए ये लेफ्ट साइड में जो मेरा दिख रहा होगा आपको स्क्रीन, यहाँ पे सब एलिजिबिलिटी क्राइटेरिया बताया हुआ है जो फैसिलिटेशन के लिए. That deity provides facilitation support to file patents of deity R&D societies, autonomous bodies, and for its inbound IPRs. Deity provides facilitation support to file patents of grantee institutions who have executed R&D project using deity grant. The assignee ownership of IPR is as per the terms and conditions of governing the grant in aid of particular funded R&D projects. ये सब चीज आज की डेट में अवेलेबल है जो है आपको.
Good afternoon, sir.
Good afternoon.
Sir, I have a question. Like few people from different universities, they got some patent granted.
Okay.
So I want to know who will be the ownership. Who will take the ownership?
देखिए
They are from different universities, 3-4 universities.
देखिए ऑनरशिप तो जो एप्लीकेंट है पेटेंट का, आपको जो पेटेंट अगर उसका अब देखेंगे, पब्लिकेशन देखेंगे या उसका जो डॉक्यूमेंट देखेंगे, वो आपको उसी में दिख जाएगा आपको हर डॉक्यूमेंट में जो है. जैसे मान लीजिए मैं आपको दिखाता हूँ, आप मान लीजिए किस तरह के पेटेंट में इंटरेस्टेड है, आप बताइए मुझे जो है.
नहीं सर, वो किसी जैसे डिफाइन किया मैंने, किसी में लिंक्डइन में देखा था.
हाँ.
उसमें 4-5 यूनिवर्सिटी के फैकल्टीज हैं.
हाँ जी.
तो हु विल टेक द ओनरशिप?
देखिए जो पेटेंटी है ओनरशिप तो उसी की है. उस पेटेंटी ने क्या एग्रीमेंट किया यूनिवर्सिटी के साथ में, वो दैट इज बिटवीन हिम एंड यूनिवर्सिटी. फॉर यू द ओनर इज द पर्सन हुज नेम इज मेंशन्ड इन दैट डॉक्यूमेंट. सपोज मैं यहाँ देखता हूँ आपको दिख रहा है स्क्रीन पब्लिक सर्च वाला?
यस सर, इट इज बिजी.
मैंने यहाँ पे पेटेंट में सर्च किया.
यस सर.
सर्च में मैं गया, ग्रांटेड पेटेंट्स में गया, और मैंने यहाँ पे एप्लीकेंट में जो है एप्लीकेंट नेम यूनिवर्सिटी लिखा है यहाँ पे. और यहाँ पे नीचे सर्च किया डाल के, जो भी कोड है ये 1EW07 W07. मान लीजिए ये इसमें पेटेंट्स हैं जिनमें एप्लीकेंट यूनिवर्सिटी है. ठीक है जी. अब मैं इसका इस फर्स्ट पेटेंट का ई रजिस्टर देखता हूं. जैसे आपकी किसी मकान की रजिस्ट्री होती है, ऐसे ही ये रजिस्टर पेटेंट है इसका. इसमें सब डिटेल है इसके कि ये पेटेंट आज की डेट में इन्फोर्स में है, क्योंकि ये अगर ये सीज पेटेंट है तो इसमें कोई भी वर्क कर सकता है. तो सबसे पहले इंपॉर्टेंट चीज ये देखने की ये है कि पेटेंट ये इन्फोर्स में है. दूसरा, ये पेटेंट किस टॉपिक पे है? ए डिवाइस फॉर मेजरिंग टेंशन इन ए वायर ऑफ एन ऑर्थोडोंटिक बेसिस. जो ऑर्थोडोंटिक बेसिस में जो प्रेशर है होता है कि भाई कितने प्रेशर पे उसको रखना चाहिए, उन लोग डॉक्टर्स को डिफरेंट इंटरवल्स पे उसका टेंशन जो है चेंज करना होता है. तो वो बड़े सिग्निफिकेंट, मतलब वो एक तरह से एपरेटस है इनके लिए जो है डिवाइस. तो अब ये कृष्णा यूनिवर्सिटी के नाम पर है, डीम टू बी यूनिवर्सिटी. तो इसकी ओनरशिप तो यूनिवर्सिटी के पास है, लेकिन इसमें अगर आप और देखना चाहते हैं कि भाई इसके इन्वेंटर्स कौन है, तो आपको इसी एप्लीकेशन के डिटेल में जाना पड़ेगा. अच्छा, इसमें देखिए आप आज की डेट में ये क्योंकि रिसेंटली ग्रांट किया हुआ पेटेंट है, अगस्त में ग्रांट हुआ है, तो अभी इसमें कोई फीस डिपॉजिट नहीं है नीचे. तो अगर ये फीस डिपॉजिट होने की, मैंने आपको उस दिन बताया था कि ये 3 मंथ्स का टाइम होता है. 13 अगस्त को अगर ये ग्रांट हुआ है और 13 अगस्त को ये रिकॉर्ड हुआ है, तो सितंबर, अक्टूबर, नवंबर, 13 नवंबर 20 तक इसमें इनके पास टाइम है फी पे करने का. अगर ये पे नहीं करेंगे तो ये पेटेंट हो जाएगा सीज होने के बाद में इस पर कोई भी वर्क कर सकता है. लेकिन उनके पास 6 मंथ और होंगे इसको एक्सटेंशन लेके इसकी फी पेमेंट करने का, वो भी निकल जाएगा। तो फिर इनके पास फिर भी 18 मंथ्स होंगे इस डेट से, जिस डेट में इस चीज का जो डेट होगी इसकी वो होगी नवंबर 20। उस डेट से 18 मंथ्स और उनके पास होंगे इसको रेस्टोर करने के लिए। अब इस पेटेंट में आप देखिए इतनी इन्फॉर्मेशन मिल गई आपको, और आप ये जानना चाहते हैं कि भाई ये वर्क करा किसने, तो मैं वापस जाऊं उसी इसमें और यहाँ पे एप्लीकेशन स्टेटस में देखूं तो इसके पूरे डॉक्यूमेंट्स मेरे को मिल जाएंगे। ये पूरा डिटेल बता दिया है इसमें। देखिए इसमें मैं यहां देखूंगा व्यू डॉक्यूमेंट्स। व्यू डॉक्यूमेंट्स में जो इसका फॉर्म 1 होगा उसमें आपको मिल जाएगा कि इसमें भाई कौन इन्वेंटर्स थे। फॉर्म 1 मैंने यहां देखा, आप सब लोग को दिख रहा है ना प्रॉपरली?
Yes, sir. Visible.
You see, so in this patent, the applicant was university, but inventor was this person, Ronald Yusuf Ahmed A. इनका इन्वेंशन किया हुआ है। अब ये एक, इसमें तो एक इन्वेंटर है, ये 4 भी हो सकते हैं। इन चारों ने मिलकर यूनिवर्सिटी को एक जरूर वो दिया होगा, एक असाइनमेंट उनके साथ किया होगा, एग्रीमेंट कि हम अपना वर्क आपको दे रहे हैं, या यूनिवर्सिटी ने कोई कंडीशंस लगा रखी होंगी कि आप जो भी रिसर्च वर्क करोगे मेरी यूनिवर्सिटी में रहते हुए उसमें पेटेंट मेरे नाम से ही फाइल होगा, आपका नाम खाली उसमें एज एन इन्वेंटर आएगा। तो ये तो बातें म्यूचुअल एग्रीमेंट की हैं उनके बीच में। तो जो आपका क्वेश्चन था कि 4 लोगों के नाम से पेटेंट है तो मैं उसको ऑनरशिप किसकी मानूं, तो आपको ऑनरशिप मानो जो जिसका नाम वहां लिखा हुआ है नेम ऑफ पेटेंटी में।
राइट सर।
अच्छा, 2 चीज और आपको बता दूं जो मैंने पेटेंट रजिस्टर ओपन किया है कि यहाँ पर देखिए नेम ऑफ ग्रांटी लिखा हुआ है, नेम ऑफ पेटेंटी लिखा हुआ है। तो जो नेम ग्रांटी होता है वो पर्सन होता है जिसको फर्स्ट टाइम पेटेंट ग्रांट हुआ है, और पेटेंटी वो होता है जिसके पास आज की डेट में ऑनरशिप है। तो इस केस में ऑनरशिप जो है वो खाली ग्रांटी के पास है। लेकिन कई बार क्या होता है कि मान लीजिए ये पेटेंटी किसी को असाइनमेंट कर देते हैं तो यहां पेटेंटी का नाम चेंज होकर उनका आ जाएगा जिनको वो असाइनमेंट करते हैं, ठीक है। और उसका यहां नीचे डिटेल लिखा जाता है उसका। मैं आपको बाकायदा दिखा देता हूं, जो है आप चाहें तो असाइनमेंट वगैरह कैसे होते हैं वो दिखाऊं आपको, हम लोग अगर इंटरेस्ट है आपको तो।
श्योर सर, श्योर सर।
सर प्लीज।
देखिए असाइनमेंट मैं आपको दिखाता हूं। मैं आपको अपना फोल्डर तो दिखा सकता हूं, यहां तो कोई प्रॉब्लम नहीं है। देखिए इस तरह से लोग अप्लाई करते हैं। ये फॉर्म 16 है। इस तरह से अप्लाई किया जाता है कि ये मैकमिल पीपीसी उन्होंने पर्सन ने अप्लाई किया और ये कह रहे हैं कि जो गारंटी है इमा नोट टाइप टी वाई लिमिटेड, इनके नाम से पेटेंट है, ये मेरे नाम पे कर दिया जाए। ठीक है जी। अब जब ये हम इसको प्रोसेस करते हैं आगे तो देखिए ये मैं आपको दिखा रहा हूं यहां पर। ये जो पेटेंट आपको दिखाया था मैंने, सर्टिफिकेट है, इसमें इस केस में बेटर चांस है कि इस केस में पहले 2 पेटेंटी थे, वो सिंगल पेटेंटी था। ये इन्होंने अपना पेटेंट 2 लोगों को असाइन किया, उन 2 लोगों का नाम आया यहाँ पर 1 और 2, वो बैक स्टेप वाली बात है। और फिर उन दोनों ने में से जो सेकंड को पेटेंटी था उसने फर्स्ट को वापस कर दिया। अब ये फैक्ट जो मैं आपको बता रहा हूँ ये डिस्क्लोज कैसे होगा, ये देखिए आप यहां देखिए जो नीचे रिमार्क्स है इसके अंदर, हर पेटेंट के तो नीचे रिमार्क्स होते हैं यहाँ पे। जो मैंने लेटेस्ट इसको 28 अगस्त को इसका एंट्री कराया है, इसमें मैंने मेंशन किया हुआ है इन परसुएंस ऑफ 2 रिक्वेस्ट इन फॉर्म 16 डेटेड 14 अगस्त फाइल्ड बाय दिस पर्सन फॉर चेंज ऑफ नेम फ्रॉम दिस टू दिस एंड बाय वे ऑफ मर्जर एंड दिस एंड, मतलब जो भी डिटेल है पूरा यहां लिखा मिलेगा आपको। और ये मेरा ही डॉक्टर एस सिंह का ही मेरा ही रजिस्टर किया हुआ है। इससे आपको ऑनरशिप का पूरा चल जाता है पता है। अगर किसी की ऑनरशिप चेंज भी होती है, मान लीजिए जैसे किसी प्रोफेसर ने अपने नाम से पेटेंट ले लिया और बाद में यूनिवर्सिटी को चला पता कि भाई इन्होंने पेटेंट ले लिया, फिर यूनिवर्सिटी उनसे मैं चाहा कि भाई नहीं, पेटेंट आपने वर्क हमारे यहाँ किया है तो आप ये पेटेंट हमारे नाम से होना चाहिए, तो वो प्रोफेसर यूनिवर्सिटी को असाइन कर सकते हैं उस पेटेंट को, तो वो पेटेंट यूनिवर्सिटी के नाम से हो जाएगा। जो भी टर्म्स एंड कंडीशन डिसाइड होंगी उनके बीच में वो म्यूचुअल अकॉर्डिंग टू दैट। और इसके अलावा जो और इंपॉर्टेंस है इसका, पेटेंट रजिस्टर का मैं इंपॉर्टेंस बताना चाह रहा था आपको। इसके अंदर इसमें इंफॉर्मेशन होती है वर्किंग ऑफ इन्वेंशन की भी, जो है कि ये इन्वेंशन कितना वर्क हुआ है। जैसे ये पेटेंट है 257,556। मैं आपको फिर से दिखाता हूं। मान लीजिए आपको ये सर्च करना है, जिस पेटेंट का नंबर 257,556 है, तो आप कैसे करेंगे, आप वेबसाइट पर जाएंगे पेटेंट ऑफिस की, यहां सर्च करेंगे यहां ई रजिस्टर में, और यहां नंबर डालेंगे 257,556 YAYVADL। आपने इसको रजिस्टर शो किया तो आपको यहां सब इंफॉर्मेशन यहां भी मिल जाएंगी। यहां से व्यू डॉक्यूमेंट भी देख सकते हैं और आप ये भी देख सकते हैं, ये फॉर्म 27 है जिसमें ये 14, 19 ईयर वाइज है, और इसके अंदर ये पूरा डिटेल बताते हैं कि इनका जो पेटेंट है वो अभी तक वर्क हुआ है नहीं हुआ है, ये वर्क हुआ है तो उससे कितनी इनको इनकम हुई है, वो भी सब आपको ये प्रोवाइड करते हैं इसमें वेबसाइट पे। और इसके अलावा भी जो है अगर आप देखना चाहते हैं तो ये सब आपको व्यू डॉक्यूमेंट में भी मिल जाता है। जो व्यू डॉक्यूमेंट, यहाँ पे जो व्यू डॉक्यूमेंट है, यहाँ पे जो ये पूरे डॉक्यूमेंट अपलोड कर रखे हैं, तो आपको जैसे मान लीजिए ये देखना है रेलिवेंट डॉक्यूमेंट, ये इनका फॉर्म 27 है जो इन्होंने फाइल किया है 17 के लिए, और इनका अभी तक कोई इसमें वर्क नहीं हुआ है। और इसमें मैं अगर कहूँ सब लेटेस्ट आप देखिए, लेटेस्ट क्या हुआ है, तो लेटेस्ट फॉर्म इनका ये फाइल हुआ है 27/19 के लिए, और इसमें भी ये कह रहे हैं कि अभी मेरा मैन्युफैक्चर नहीं हुआ है इंडिया में। अगर ये मैन्युफैक्चर होता है, इससे जो भी इनकम होती है उनको डिटेल यहाँ बताना पड़ता है यहाँ पर। तो मैं इस तरह से अब I got an opportunity to explain you the role and purpose of this patent register also. अगला सवाल पूछिए कुछ।
सर अभी कुछ वर्क नहीं हुआ तो क्या क्या होगा इस पेटेंट का?
वर्क नहीं हुआ तो देखिए, एक माना जाता है कि पेटेंट जितने भी फाइल होते हैं उसमें से वेरी फ्यू पेटेंट्स आर इकोनॉमिकली वायबल। मुश्किल से 2 या 3% पेटेंट वर्क होते हैं। लेकिन आपका वर्क नहीं होता है तो आई कैन ओनली से दैट इट विल गिव यू फर्दर नॉलेज टू जनरेट नेक्स्ट पेटेंट आउट ऑफ दैट पेटेंट, और विच मे बी वायबल फॉर फ्यूचर कॉमर्स। अदरवाइज नहीं वर्क हुआ तो नहीं हुआ वर्क, उसको आपको कुछ किया नहीं जा सकता। 20 years के बाद में
नो एक्शन विल बी टेकन ऑन
जी
सर, ऑफिशियली कोई एक्शन नहीं लेते हैं ना उस पेटेंट के और इन्वेंटर के ऊपर?
नहीं, कोई नहीं देते हैं। अगर आपने नहीं वर्क हुआ तो नहीं हुआ, लेकिन आपको एवरी ईयर ये हमको इन्फॉर्म करना पड़ता है। जो फॉर्म 27 है, ये फॉर्म 27 फाइल करना इज ए कमिटमेंट विद कंट्रोलर। ओके
ओके सर, अंडरस्टैंड।
पूछिए सवाल को नेक्स्ट आपका।
Any other question? If you have any question, please write it in chat box. Sir, कुछ questions हैं in chat box में।
हाँ भरत जी, मैं ना दूसरे प्रोग्राम में हाँ मैं अभी बस 5-10 मिनट में वाइंड अप करके आता हूँ वापस। ठीक। एनी क्वेश्चन?
सर चैट बॉक्स में कुछ क्वेश्चंस हैं।
बोलिए भाई 98 पार्टिसिपेंट्स हैं, सबको सर्टिफिकेट चाहिए।
Sir, excuse, sir, myself Manoj. Suppose, sir, yes, sir. Suppose I have an idea regarding. Suppose I have an idea regarding product design related to a whiteboard.
Yes.
Like in these days, whiteboards are in demand, but they are in certain form. But I have an idea that is completely different than the available in the market, in particularly Indian market. But since I am a physics student, I cannot go for fabrication. That is the in specification for mechanical engineers or design. And in that case, what should I do? Should I go for a pattern design if I can make a complete diagram of that and all related design works?
It is said that one should procure any time the property which is as much as possible to remain in his hand. ठीक है?
Yes.
When even you are going to buy something, you intend that it must be durable.
Yes, sir.
So you have to see that if you are going to protect your intellect, your intellectual property, then what way you will be able to protect it strongly. So as far as design discussion is concerned, design is only for aesthetic value. Suppose you have made that whiteboard in the shape of heart.
Yes.
So and you got it, you got design registration of the same. Then you can stop any person to make whiteboard to the shape of heart. Anybody can make it rectangular or circular shape or any other shape.
Yes, sir.
So that way, there is no strong hold on your IP by that instrument of design registration. But at the same time, if you find that what material you have you are using for your preparing your new type of board is totally different from the previous type of material. You have made a different composition in that material as to make it strong, to make it smooth, to make it applicable by chalk also, by pen also, by something. You can write by finger also. Somewhere you are able to make such structure or some composition. Then you should exercise that. You can get patent in composition used for that preparation of that board. Okay. Suppose you have made some hinges, some clips, something of innovative type in hanging that board or displaying that board. Then you can go further claiming the patent in that development of that hinges or something that you have where you have applied your mind, which is not of the common type of application.
Yes, sir. If it will be very uncommon type, then the commercial available different types of products.
First, you have to see that what is your contribution in doing that, and that is the purpose of this seminar. That so that you can identify your IP, whether it is a design, whether it is a trademark, whether it is a copyright, whether it is a patent.
Yes, sir.
Okay.
Thank you, sir. Thank you.
Okay.
Sir, some questions are written in chat box. Please check, sir.
Next question.
Suman sir. Hello, sir.
Haji.
Hello.
Hello.
Good afternoon, sir.
Good afternoon.
My question is that if I don't want to file my application in India,
okay,
whether I can go directly for PTC?
PCT. Patent Corporation Treaty. For that, you have to take permission in Form 24 from this office.
Okay. So
you see, this is a serious matter that if you do not take that permission, contravention is something serious. There is a provision of imprisonment also for that.
Okay. But if I take permission, I can directly go for the international patenting.
Yes, sir, definitely.
It is not required that I have to file in India.
No, not necessarily.
Okay.
If you are permitted, you can file in any country.
Okay. One more thing, sir, how do you check the secrecy of patent application and exactly when you check it? Section 35.
Yeah, we simply forward your application, which are prima facie visible to us, our controller. There is a section in which a controller has been acquainted with the possibilities to judge that prima facie this invention is of for atomic purposes or for defense purposes. In that case, he forwarded to the Ministry of Defense or Department of Atomic Energy, and they have their own cell. They decide whether really it will affect by your granting patent to this person, to this department or this country or not. When they clear it, then we publish it. It goes further. But the final decision is that of Department of Defense or Department of Atomic Energy.
Okay, but when actually it happens actually within the 18 months period, first 18 months period or after that?
No, it happens, forwarding of application, it takes place as soon as it comes before the department for screening. But we have compulsion that it should not be published. It should take place before 18 months, and normally in first 1 or 2 months we are able to screen the invention if it is affecting atomic energy or defense purposes.
Okay. Thank you, sir.
अब थोड़ा सा आपको दिक्कत बता दूं, प्रॉब्लम ये कई बार आती है कि वहां से देरी में आता है हमको जो है कंफर्मेशन। तो बहुत बार ऐसा हो जाता है कि आपको जो टाइम आ गया है 18 मंथ्स पब्लिकेशन का वो क्रॉस कर जाता है।
ओके।
तो कुछ इसमें प्रिविलेज प्रोविजंस हैं कि आपकी सीक्रेसी डायरेक्शंस को कंसीडर करते हुए जो कुछ नुकसान होता है उसका कंसिडरेशन पेटेंट एक्ट में है।
ओके।
आपको टाइम लॉस होता है।
हाँ।
बाकी पर्पज उसका क्या है अभी हम लोग डिस्कस कर रहे थे, बट that Department of Defense has not made any guidelines that which type of invention are to be considered as defense related.
Okay.
मान लीजिए कोई सॉफ्टवेयर इस तरह का है कि भाई जिसको एरोप्लेन में लगाने से जो है वो एरोप्लेन जो है बहुत अच्छी तरह से कहीं जाके हमला कर सकता है, वापस आ सकता है, या कोई ऐसा राडार सिस्टम है। तो मतलब डिसाइड कैसे करें कि भाई किस हमसे गलती ना हो जाए ये डिसाइड करने में कि भाई इस एप्लीकेशन को आप फॉरवर्ड करें या ना करें। तो सर्टेन गाइडलाइंस होना चाहिए, जो जैसे एटॉमिक एनर्जी के केसेस में तो है कि अगर ये एलिमेंट है, रेडियो एक्टिव एलिमेंट है, तो आप उसको हमको इन्फॉर्म करने के बाद ही प्रोसीड करेंगे आगे।
ओके।
और वैसे अभी कभी ऐसा मेरे सामने कोई इंस्टेंसेस आया नहीं है, बट द पर्पज इज that invention is so important, so valuable that maybe defense of ministry wants it to hold for themselves. But we have not come across like that. In that case, the Ministry of Defense has to make a contact with the applicant that please don't publish this invention, don't go for the patent. Whatever money you want, we are ready to give you, and you please give all technology to us with terms and conditions.
ओके। अगर बाय चांस वो पेटेंट ग्रांट हो जाता है तो बाद में भी वो ये कर सकते हैं ना डिफेंस वाले। हम लोग चर्चा कर रहे थे कि जो डिफेंस को कोई आपसे दुश्मनी नहीं है कि आपको उसको पेटेंट मिलने नहीं देना है। डिफेंस को फॉरवर्ड करने का पर्पज ये है कि अगर वो डिफेंस के लिए वैल्यूबल है तो हम उसको डिस्क्लोज ही नहीं होने देंगे, हम किसी को बताएंगे नहीं। ओके।
अगर वो ग्रांट हो चुका है, सब पब्लिश हो चुका है, तो अब वो वाली बात है, अब रोक के क्या किया जाएगा। अगर कुछ ऐसा पेटेंट हुआ जो हार्मफुल है इस कंट्री के लिए और वो एटॉमिक एनर्जी अट्रैक्टेड है, डिफेंस अट्रैक्टेड है, तो हो सकता है डिपार्टमेंट उसको जो है रिवोक करने के लिए बोले हमको।
ओके।
लेकिन उसको तब तो पर्पस तो लॉस्ट हो जाता है ना।
जो आदमी मान लीजिए आपने कोई ऐसा पेटेंट ले लिया, हालांकि पेटेंट तो मिलेगा ही नहीं आपको, जो चीज मॉरली जो है जो हार्मफुल है हमारी कंट्री के लिए, जो मॉरली जो क्या बोलते हैं, जो ग्राउंड है ना हमारा इसका सेक्शन 3 का, इन्वेंशन विच इज फ्रिवलेस और क्लेम्स एनीथिंग ऑब्वियस कॉन्ट्ररी टू वेल एस्टेब्लिश्ड नेचुरल लॉ. The invention, the primary or intended use or commercial expression of this is contrary to public order or morality, or which causes serious prejudice to human or animal or plant. ऐसी चीज पे पेटेंट हम देंगे नहीं आपको.
ओके.
तो मान लीजिए ऐसा कोई पेटेंट ग्रांट हो जाता है जो डिफेंस के काम का था, तो ठीक है, डिफेंस को इंटरेस्ट होगा तो डिफेंस आपसे कॉन्ट्रैक्ट करेगा, आपको आपसे लाइसेंसिंग लेगा, प्रोड्यूस करेगा.
Okay. Sir, is the same process is adopted for the especially UAV unmanned aerial vehicle patents? Because these things are like unmanned aerial vehicles are related to civil aviation as well as military aviation. So
हाँ, तो इससे तो कोई एप्लीकेशन होगा तो डेफिनेटली हम उसको फॉरवर्ड करेंगे डिफेंस मिनिस्ट्री को.
Okay, sir.
पूछिए सर, नेक्स्ट क्वेश्चन पूछिए.
Hello. Hello.
Dr. Singh, this is Avinash. I had a question. The term abandoned is used when full specification is not filed after provisional, or when the patent is granted but the maintenance fees is not paid.
देखिए, मेंटेनेंस फीस जब पे नहीं होती है तो वो टर्म यूज होता है सीज्ड, तब अबेंडन यूज नहीं होता है.
क्या यूज होता है सर, फिर से रिपीट करिए.
अबेंडन यूज होता है खाली 21 में जब आपको वो भी डीम्ड अबेंडन होता है. अबेंडन हम नहीं करते हैं, वो अबेंडन माना जाता है, डीम्ड अबेंडन हम कभी अबेंडन नहीं करते. अगर आपने प्रोविजनल फाइल कर दिया, कंप्लीट फाइल नहीं किया, तो हम मानते हैं कि भाई आपके पास इन्वेंशन है ही नहीं, तो आपका वो डीम्ड अबेंडन हो जाता है. आपने अगर पेटेंट फाइल किया और आपने उसमें रिक्वेस्ट फाइल नहीं किया 48 मंथ्स के अंदर, मतलब आप उसमें चाहते नहीं है, तो वो दैट विल बी ट्रीटेड डीम्ड अबेंडन, ट्रीट किया जाता है. हम अबेंडन नहीं करते हैं कभी.
ओके सर. एंड जब मेंटेनेंस फी पे नहीं करते हैं ग्रांट के बाद, तब उसको क्या बोला जाता है सर?
सीज्ड.
ओके.
हाँ, सेक्शन 54 में पढ़िएगा, सेक्शन 54 ही तो है. 54 में है 53, section 53, a patent shall cease to have effect notwithstanding anything therein in this act on expiration of the period prescribed for the payment of any renewal fees. और सुनिए, notwithstanding anything contained in any other law for the time being in force on cessation of the patent right due to non-payment of renewal fees on expiry of the term of patent, the subject matter covered by the said patent shall not be entitled to any protection. Any person can work in that invention.
अंडरस्टूड सर. डॉक्टर सिंह, एक और रिलेटेड क्वेश्चन था, पॉलिसी क्वेश्चन, कि जो रिन्यूअल फीस होती है सर, क्योंकि ग्रांट हो गया, सारा प्रोसेस हो गया, तो रिन्यूअल फीस का मेन ऑब्जेक्टिव रेवेन्यू जनरेशन है गवर्नमेंट के लिए कि और कुछ है?
देखिए, ऑब्जेक्टिव तो देखिए रेवेन्यू डिपार्टमेंट ही बता सकता है. मैं जैसे आप सोचने की कोशिश कर रहे हैं, मैं भी कोशिश करके बता सकता हूं आपको. इसका पर्पस ये है कि हम ये चाहते हैं कि आप उसी ही टेक्नोलॉजी का पेटेंट लें जो वर्दी इकोनॉमिक वायबल है. आप ऐसा ना हो कि आप अननेसेसरी पेटेंट लेते रहें और फिर उसको रिन्यू ना कराएं. रिन्यू कराने का मतलब ये है कि आपका अभी भी इंटरेस्ट उसमें है, और अगर आपका इंटरेस्ट नहीं है तो ठीक है, उसको सीज होने दीजिए. लेट पब्लिक एफिडेविट का जो है
Which one is best?
नहीं हो पाएगा. मैंने कहा मेरी तरफ से कोई हो तो नहीं, मैं थोड़ा सा कर दूंगा बिना उसके लिए. आज तो वैसे भी नहीं होगा. आज क्या, आज तो मेरे साथ में है. हाँ जी, वो अगला क्वेश्चन पूछिए।
Singh sir,
हाँ जी,
sir, we have some questions in chat box.
चैट बॉक्स में कौन सा वाला क्वेश्चन जी? इज देयर एनी फीडबैक लाइक हमने अबेंडन वाला तो बता दिया, अविनाश सिन्हा जी का आंसर दे दिया। कौन सा इंडिकेट कीजिए, कोई रह गया हो तो जो है।
Okay.
Sir, there is a question like,
सेक्शन 18 आईपीए, ये तो गवर्नमेंट का डिसीजन है।
sir, another question is there. How do you
वाई
check
का
the
आंसर तो गवर्नमेंट
secrecy of
जानती
the
है।
secrecy of the patent and when do you check it?
हम तो ये कह सकते हैं इन द इंटरेस्ट ऑफ दिस नेशन।
Sir, I am putting a question in chat box. Just
Is there any please explain some practical incidences with regard to patent and litigation? किस तरह का आप चाहते हैं हनुमंत सिंह जी, किस तरह का प्रैक्टिकल इंसिडेंस जानना चाहते हैं हम? हाँ हनुमंत सिंह जी, मैं आपका इंतजार कर रहा हूँ, किस तरह का जानना चाहते हैं लिटिगेशन इंस्टेंस? एनीथिंग सर, इज इट इट्स लाइफ साइंस? लिटिगेशन किस एस्पेक्ट पे जानना चाहते हैं आप?
सर ये इट ऑडिबल सर? हेलो हेलो, इज इट ऑडिबल?
Yes, yes, audible. Please continue.
Sir, if like suppose we are filing patent related with genetic engineering plant or something,
yes,
and later it has been comes in. Hello.
Yes, yes, sir. I'm able to hear you.
Yeah. Sir, suppose if we are filing any genetic engineering plant, genetically modified plant,
yes,
and later it has come under the litigation of using some enzyme which is already patented by someone else. So in that cases, what will be the outcome? Is how to defend that things?
To see how to defend is, I mean, something, I mean, very specific. What strategies to be adopted, and that depends upon the case to case. And I can only say that if genuinely the same thing is patented earlier, and then you have to lose your rights, because from granting patent does not guarantee that this invention was really not existing earlier. In our law, we say that patents examination by this office as to novelty and inventive step does not warranty. If you read the section 13, subsection 4 of section 13, the examination and investigations required under section 12 and this section shall not deemed in any way to warrant the validity of any patent, and no liability shall be incurred by central government or any officers by the reason of or in connection with any such examination or investigation or any report or other proceedings consequent thereon. This means the burden to protect in the court that technology as patented was really not known previously, and the person who is claiming that this was known previously, that technology is quite different from my technology, that burden is onto the patentee.
Okay, sir, actually what I was asking is that the technology is the new, but the enzyme we have used to change or modify the any plant genetic character,
yes,
the enzyme is already patented by someone else.
Yes.
What will be the outcome in that case?
No, if it is patented by someone else, and you think that just by changing the enzyme, if that is something which is not, I mean, a common, I mean, knowledge of the person and of that art, then in that case you can claim your different patent. But if you think that that is something obvious to the previous knowledge, and whatever was patented in that patent was also, I mean, very common to the knowledge of a scientist working in this field, then you have any difficulties in your, I mean, your production of your product in your industry, then you can file a I mean, case against him that for revocation.
Okay, sir. Okay.
And you, if you think that that the change of enzyme, I mean, is totally some beyond, I mean, imagination of scientists working in that field, then you can claim your own patent for the same.
Okay, sir. Sir, any other examples, kind of things with any field you have come across, because you are dealing with all the patent things, so
नहीं, अब देखिए ये
some incidents was happened during this
अभी आप देख लीजिए, मॉन्सेंटो का केस हुआ था, मॉन्सेंटो का, तो उसमें देख लीजिए, इंटरनेट पे आपको मिल जाएगा, मॉन्सेंटो के नाम से जो है बहुत बड़ा लिटिगेशन हुआ, उसमें जो है हमारे कंट्रोलर ने डिसाइड किया कि ये पेटेंटेबल नहीं है, फिर कोर्ट ने, हाई कोर्ट ने कहा साहब इसको रिव्यू कीजिए, कुछ हुआ उसमें, दैट मे बी आप वर्दी टू योर नॉलेज, आप उस मॉन्सेंटो के नाम से सर्च करके देखिए, आप मॉन्सेंटो पेटेंट।
जी सर। ओके सर, थैंक यू।
ओके जी, अब मुझे याद मिलेगी तो मैं अपना थोड़ा सा, मेरा भी प्रोग्राम इंटरनेट चल रहा है, उसको मैं अटेंड कर लूं।
यस सर। हेलो am I audible, sir? Hello.
Hello, sir. Sir, please stop scaring your screen. Otherwise, whatever you are doing in your official work, it is showing to others.
Organizers, excuse me, is this session over now, or is there anything else?
Hello.
Am I audible,
Avinash ji?
Yeah. Please tell me.
Okay. Now session is over because sir have some meeting. That's why they leave. And if you have any question regarding STC, then you can ask. And within 1 or 2 days, within 2 or 3 days, we will send a feedback form to you. Then after that feedback, you will get certificate, right?
Excuse me.
And whatever PPTs we have received from the expert, we will share with you with that feedback form.
Okay, thank you.
Excuse me. Is it audible?
Yes.
Can you share the recorded video to us?
It is available NITJ official channel. I will also share the link for these videos.
Yeah, that will be much better. And
Okay,
if
okay.
possible, you can keep now also in your chat box if the link is there with you.
Yeah, just I am putting that link. Don't take tension.
Yeah, please. Okay. Thank you.
Hello.
Yes.
Sir, I want to ask that if you will provide the feedback link within 2 to 3 days,
yes.
Is there any time limit to respond it within 4 days or 5 days?
It will be mentioned in that mail, right?
Okay. So if someone is busy in something and I can reply after 5 days, then is there any
It will take only 2 minutes, not more than 2 minutes.
Actually, my phone will be switched off. I will be out of bounds for some days after 2 days.
Okay. So I will try as soon as possible, as early as possible. Try to send it, right?
If you can do it as early as possible, then it will be fine for me also.
Right. And you can find the link. Already shared the link.
Okay.
Right. Any other query?
Okay. Thank you so much.
If you have any query, then you can mail me, right? Okay. Thank you. Bye.
So feedback form will be sent on email?